I've got my buddy, attorney John Civils, with me here today. Good morning, John.
Hey, Bernard, how you doing today?
Good to see you, bud. A little bit better. There we go. Almost. Today, we're going to talk about workers' compensation. We're going to talk about the mediation process. But before we get to that, I want to introduce my friend, John Civils. John has been a longtime attorney and litigator in Birmingham and throughout the state. Very well respected, and I've gone to battle against John over the years. I've sought counsel from John over the years, so I really appreciate you having some time to spend with us today.
Well, I appreciate it, and thanks for having me. And Bernard and I were talking earlier, today's 9/11, and I know we all remember that day, whatever we were doing on that day. I remember I was going into work, heard it on the radio, and called my wife Debbie, and then we got into work and watched it on TV. So can't help but, as Bernard and I were talking about, remembering the horrific thing and all the heroes and heroism that arose from that day. And so I appreciate being asked to come in. As Bernard said, I grew up here in Gardendale and began practicing law in 1977, did 2 years at Birmingham Area Legal Services. Great experience, wouldn't trade it for anything. Then went with Huey, Fernie, Buchan, Stewart in July of '79. Practiced for a little over 38 years with them, so about 40 years. And mediation, when I started out, I did everything. I did products liability, slip and falls, false arrest, workers' compensation, automobile accidents. You did everything. Did some plaintiffs' workers' comp, defense work comp. And as my practice grew, I ended up doing more workers' comp, some coverage things and other things. And then in the early 90s, I went for training in mediation and then began mediating. And about 8 or 10 years ago, started doing it in earnest, and also doing appellate mediation. And then, that's what I really loved and enjoyed. And my wife Debbie and I had been talking about it a long time. I've been practicing for 40 years. I said, I'd really like to retire from the active practice of law and just mediate. She said, do it. She's been great to say. She said, I'll keep working. You go do what you enjoy. So I opened Civils Mediation in January of 18. My firm's been great that I use, the offices to mediate everyone. I miss my friends there, but I have thoroughly enjoyed this because mediation is what I enjoy doing. And
well, we're going to talk a little bit about that today, John. As you guys know, from each week we come to you on NOMBERG Law Live. One week we'll talk about some area of the law. It could be work comp, it could be personal injury, it could be Social Security. Other weeks we talk to folks who aren't involved in the law, local leaders in the community, sports people, etc. But today we're back in the area of law. We're talking about workers' compensation, which is a really unique set of laws in Alabama. It is, I believe, the only state in the country that has litigation-based practice as part of the law dealing with work comp. Doesn't have to be litigation-based, but a lot of times there are issues between the two parties, and sometimes you have to get a judge to deal with it. Well, that's where John comes in. John, for years, has mainly represented employers or insurance companies, but after, as he said a few minutes ago, he's now transitioned, beginning earlier this year, into a mediation practice. And one of the great things about our work comp laws here in Alabama is at any point in time, the parties can either come together voluntarily or they can be brought together by a court order, but that's where you come in. And I want to talk, John, I want you to briefly explain in general, what is the mediation process as a whole?
Well, I kid people and I say the two most successful things that I've seen in practice of law is the development of travel transcripts, and rather than carrying around transcripts that thick, we now do it, and mediation. When I first started practicing, we didn't have mediation. You'd be on the phone on Thursday, Friday, right before trial, getting it ready, everybody talking, maybe walk up to the courthouse, the judge would send you back to go talk to get it settled, and everybody kind of ruined their weekend. It was a lot of this and that. And then mediation started developing, and it's been highly successful. And as a result, many courts, I think, now require mediation for they'll even set the case for trial. And as you said, a lot of people now, the more mediations I'm doing, there's no litigation pending, but the parties want to go ahead before that and see what they can do. And so the mediation process has been great at bringing the parties together as we go through it to try to resolve the dispute.
A lot of our clients are very nervous about going to trial, and rightfully so. It's not where they spend any of their time, and what they see on TV or in the movies, that's their first and maybe only way that they have observed what goes on in a courthouse. But what I have found from a mediation standpoint is that it really is, it's kind of a lot more low key than that high pressure, at least in the mind of the clients, of having to go to a trial. What's been your experience?
It is. And I tell you, one of the unique things about it, and I still, when starting mediation, I take about 5 minutes with all the parties together and kind of explain what a mediation's about. It's a window of opportunity to get it resolved because it's in the judicial process, and ultimately the courts are going to resolve it. And this is everybody's chance to have input, not just on the terms they want, to have input into it. And we talk about that. And it's the first time, a lot of times, that the injured employee or plaintiff has had a chance to talk with a neutral about their case. They've talked with their attorney. They may have been deposed by the defendant. Now there's somebody else in here that's a neutral. They're not on either side.
Right.
And I think they begin to identify this as a process. It's kind of like having your day in court, and then go in as the process develops.
Well, for those of you just joining us, and I see we got John Goodman, Mr. Miller, Mom, Chris Coran. I don't know if you're still there, Chris, but sends his best regards to Professor Civils.
Thank you.
Thanks for the shout out.
3 of the best years I ever did was teaching workers' comp at Cumberland. I hated the day I had to walk in and give that up. It was fantastic, wonderful students. And you talk about when you're teaching and you think you know a subject matter, and it's 2 steps forward, 1 step backwards, or sometimes one step forward, 2 steps backwards at the end of the day when I finish the lecture.
Well, Chris, thanks for the shout out. For those of you just joining us or are going to pick us up later on, I'm talking with John Civils. John is a longtime attorney here in Birmingham. He's been in the work comp world for many years, just transitioned out of private practice and now has his own mediation firm here in town. And we're talking about mediation process in work comp claims. And John, that leads me to the next thing I wanted to bring up in this process is, as much as we try to prepare our clients for that big day, it's not a day where they're going to testify, but they can still share with you privately their position. What has been your observation for those injured workers who are trying to get out their story to you? What is it that you're hearing?
Well, I think that's one of the most important sessions I have. In my initial session, which only takes about 5 minutes usually, I talk about confidentiality and explain 2 kinds of confidentiality. One, the overall process. I can't be called as a witness. What people say can't be done. But when we break down into the caucuses, that the parties can tell me things confidentially and let me know that. And so we kind of lay all those things out initially. Then my first session is normally the longest with the employee because, I want to have the employee tell me, how this affects him or her, not just how it affects them in terms of their work and their injury. It affects their life. To them, it's more, we as workers' comp lawyers know we ultimately put on the binoculars or the focus on it as to how it's going to affect their earning capacity, whether it's scheduled member, not scheduled. But this affects their whole life a lot of times, their relationship, their income and all that. And so we spend a lot of time with them just telling me a little about their background, their education, their background, their work history, how they got hurt, how this affects them, things of that nature. And I found that to be one of the most beneficial things because I think to do a successful mediation, the injured party has to trust me and understand that, I have a concern about them and working with them and in terms of making sure that they understand the process. So, those are one of the things. And I think that's the one thing the attorneys, we work with very, very good skilled workers' comp attorneys such as yourself and David. And a lot of times the employee has been really well prepared, but sometimes when it also comes from the mediator explaining to them a little of this stuff and going through it, it helps reinforce it.
One of the things I meant to mention earlier is through the Department of Labor in the state of Alabama, we have what's called an ombudsman program. And there's about a dozen men and women who have been hired and trained by the state of Alabama to go across the state to mediate cases. Well, they're not always available. That's where John comes in. John, you're in private practice with your own mediation firm, so you charge a fee that's usually either split by the parties or an agreement one side pays or the other, but your rates are incredibly reasonable. You bring a tremendous amount of knowledge and expertise to this, and I really hope that more and more people see that you're out there, and I'm hoping that today is a way to bring some attention to that.
I appreciate it, and the Ombudsman, as you said, does a really good program. It's a really good program for the state, and it's very helpful. And there are lots of good private mediators, most of whom I'm good friends with and have practiced with in the state. But there's, I think, a good role in area for private mediators to help, particularly when you have, a lot of times it's not just a workers' comp claim. You may have an RD claim. You may have other outrage cases, things that may be a third-party claim involved where you're dealing with a lot of difficult issues on the workers' comp issue with credits for future medical, credits as to potential settlement against future comp that may be owed. So those are the things in the more serious cases that we really see coming to us as private mediators, I think.
For those of you just joining us, hey, Shane, Arthur Price, Andy, Kevin, I appreciate you guys stopping in for a minute or two. And if you've got a question for John, just throw it in the comment section. We'll see it and make sure that he gets the questions either now or if you happen to watch this later on when we repost it. John, I have often heard that mediation, which can be the final resolution of a case instead of a trial, it allows both sides to get out what they need to say. It's not evidence that's being presented to you because there's no formal record, but it seems like, at least from my perspective, representing the injured workers, it really lets them get it off their chest. It really lets them just de-stress, hopefully, at the end because they've been able to explain to you. Are you seeing that? Do you hear that from them?
I agree. I think not to use a much used word in this state, but it is a process. And I became convinced that negotiation several years ago when I went to a seminar that someone presented was a process, and mediation's a process. And as the individual, the employee, the injured plaintiff, they start to see that process work and go through it with going back and forth, discussing the issues and everything, then I think they begin to feel, as I said, they're kind of having their day in court. There's something to this, it's a process. They're going back and forth. They're saying, the give and take, they're giving up, but there's also some concessions coming from the other side. And one thing I'll go ahead and say now so I don't forget it, I think that one of the most important things about a mediation is a dynamic that will occur in most successful mediations at some point. Well, largely the parties will show up and people are saying a lot of times saying, well, I'm here to see if the case will settle. I'm here and we'll see if everybody's reasonable. We'll see if it can settle. We'll see. And as it goes in and the people start working at it, both parties, you see a dynamic develop, which is now the parties aren't here just to see if it will settle. They want to settle this case, okay? And now you're going. People are willing to make decisions. They want to see this case resolved, and that becomes the key dynamic as it goes along, I think. And everybody, the employee and the employer, they get involved. Now they want it settled, and they really work on getting it resolved.
Well, I've often heard that the best mediation is nobody's happy, but everybody's satisfied.
Right.
It's a negotiation. It's a back and forth. John, how long do these mediations typically take in a given session?
It varies. You may have mediations for 2 or 3 hours. They may be 6 or 8 hours. I mean, what I try to do before a mediation, a couple of things is get a report if I can from the parties. I want to have the basic information, MMI, TTD, know about the injury, the vocational, FCEs, know a little about it. And I do that either with people giving me written reports or talking with them on the phone. The other thing I try to do is before the mediation, a few days before or day before, I like to talk with the attorneys. Just call them up. There's no substitute for the old-fashioned telephone call.
That's
so just
right.
really say, hey, anything, Bernard, I need to know about this in particular. And somebody might say, well, I'm having a little client difficulty on this issue. Can, look out, for this, or things of that nature, like say, who's going to be there with the employee? Is it going to be their spouse or a family member or what? And that's invaluable to do that. And so that kind of preparation helps a lot. Another thing I do in the opening session, I'll tell the employees that, at some point, or in the employee and defendant, I may just get, everyone's different, I may just get the attorneys together. And a lot of times, it doesn't happen in every mediation, but a lot of times we're sitting here and we just about got it, but we've hit a rough edge on 2 or 3 things. And I'll get the lawyers together, just us together, and talk. Sometimes I'll just talk one-on-one with the lawyer. If I have to say, look, I don't think your client's being realistic, whether it's plaintiff or defendant. And I don't want to sometimes say that to them in front of their client.
Sure.
That'd be counterproductive. And I let the parties know I'll do that. But a lot of times with the attorneys I work with, they're very good, fine attorneys by and large. And we'll get together and they'll talk and work it through. And, we do that sometimes when we have some rough edges.
And John, the effect of bringing to a closure a settlement agreement between the parties, that has a similar effect as if you went to a trial.
It does. And I think, I'm not aware, knock on wood, of any case where we've settled in mediation with, parties reached a settlement, where later somebody said, oh, I'm changing my mind. I mean, you do have that some, but as you said, Bernard, once they get to that point, they want to settle and they enter into it, it's closure. People are ready to move on. They've had their input, and the judicial system is the best system we have, but it's time consuming. It takes a while. You can have appeals. It's costly, and this gives the parties
brings some closure.
It really does. It brings closure. And what we do is I always still, at the end of the day, when we've reached a settlement, bring everybody in the room. We say, thanks for working hard, shake hands, good luck, etc., and do that.
And everybody takes a signed copy of the agreement. Want to say hello to Morris up in Huntsville. Got Matt Munson. Hey, Scott, good to see you guys. If y'all got any questions, I'm talking with mediator John Civils. We're talking about the Alabama work comp system and process. John is a mediator in private practice, and a very successful one at that. John is, in his years of private practice and now being a mediator, he's probably seen or dealt with all of it at one point or another. But we appreciate you guys spending a few minutes with us. And as we wind down, John, I've got just a couple other things I want to go over about this. What percentage of your cases have settled through mediation? Well, you're the acting mediator.
It is probably 90 to 95%. It is a very, very high percentage in the cases where either you haven't tried the case or there's a case pending. Now, appellate mediations are a little different. I think the parties, I got a couple of those coming up in the next few weeks. The parties have to be much more realistic as to where they are, because you had a court rule. Now, some of them are public hearings you have, but others are summary judgments or trial rulings. And you got to be more realistic. Those don't settle as a high percentage. But one of the good things about the mediation process is you do have the unknown. And I tell people in mediation, one thing I've learned after 40 years, Bernard, maybe on both sides of this, is there's no case that is so good that it can't be lost. And there's no case that's so bad that it can't be won. And sometimes we have to remind everybody of that. And that's the nice thing about the mediation.
Wise words. John, in closing, what words would you say to people who are watching this, who may be injured on the job and they're headed toward a mediation? What would your words be to, first of all, to an injured worker? What would you say to them? And then, if you put your other hat on, what would you say to the employer, just in general, in preparation for mediation?
Well, you mean as the attorney in preparing for it? Yeah, as the attorney for the employee, I would sit down with them, explain to them. One of the hard things, I think, in representing employees that you probably haven't explaining to them about workers' comp is the limitations of the act, and that it's not like a slip and fall. It's not like an automobile accident where a judge can just come in and award you a certain amount of money, but rather the judge has to look at other issues. And these are unique issues to workers' comp. I mean, we spent years doing them, but for the employee, understanding all this, loss of earning capacity, schedule, non-schedule, all that. So I think meeting with the employee before to kind of explain that to them, to know what to expect in the mediation in terms of those, and that their expectations will somewhat be governed by the compact. And that's one of the things I do in a lot of sessions.
Sure.
The other thing on the defense side is that the attorneys, and really on both sides, but they need to crunch their numbers, make sure they have all the proper things on the TTD, what's been paid and all that, and also to prepare their clients in terms of saying, well, you may think that this case only has a certain amount of exposure, but you may be looking at the potential of a permanent total, and you may think it's limited, but there's a value to that. Sometimes we look at it and I'll say, well, you got your best or worst case scenario, your best case scenario here of what you're going to get from the comp. If people want to settle medical, that has a value. If they want general releases and that has a value. If you've got a potential of a PT, if the parties are arguing that, you got to assess that. Maybe a high percentage, a low percentage. But to come prepared, and for the defendant to come prepared on all those issues in that regard.
Well, hopefully both sides have been properly prepared by their counsel leading up to the day, so there's no real surprises, but you can't always predict everything that comes up. Well, John, this is just such invaluable information. I sure appreciate your expertise and time.
Thank you very much for asking me to go and to come and do this. And, it's great. And I'm not just saying this. Those of you who practice workers' comp, and particularly in Birmingham Workers' Comp Association, the bar, it is great to have wonderful attorneys like you and David and all the others. And we have a good camaraderie and working relationship. The attorneys work hard to represent their clients, but people do it in a civil, respectful manner and working with the other side. And that's one thing I've enjoyed about comp.
I would completely agree with you, John. Guys, thank you for your few minutes today. I appreciate you watching us live or later on when you get a chance. I've been speaking with attorney John Civils. John is a mediator, mainly in workers' compensation and appellate type cases. Thank you for spending a few minutes with us. We hope that the rest of your Tuesday is a good one. I know today is an important day for many Americans and folks around the world. It's a day of reflection and remembrance. We will be back again next Tuesday, as we always are, 10 o'clock Central, 8 a.m. Pacific, and we will catch you another time. Take care.
Thank you.